Hey, it's Anthony Bandier here, attorney for Blue to Gold. Let's talk about seizing evidence in plain view, but the evidence is actually behind a locked gate. Okay, so the officer says officers respond to a property that is fenced in and gated with a lock. Okay, the victim is on scene and with a GPS device pinging to the stolen property. The property was a box trailer, a small box trailer. Based on the victim seeing and describing the property as well as the GPS pinging the location, is that enough probable cause to enter the property to further inspect for a serial number, or is a search warrant needed? Okay, so let's lay some foundations here. First of all, this is probable cause all day, twice on Sunday. This is clearly a fair probability that that utility trailer that he is, that you're looking at is his trailer. I mean, especially the pinging, of course, is really, really good. He probably has some other evidence. Maybe it's registered to him and so forth. But yeah, but you believe the witness, the victim. He has that evidence. We have probable cause. We know that a judge, based on these facts, is going to give you a search warrant to go into that. If you ask for it, to go in there and recover that trailer. You don't have to read the VIN, and actually that's called certainty. Yes, you'll have certainty after you recover it, but you don't need certainty to go get a search warrant. Now, do you even need a search warrant? Well, we have plain view is right to be, right to see. We have plain view. Plain view seizure requires lawful access. Do we have lawful access under here? The answer is probably no. This sounds like this may be curtilage. And so curtilage is an area around a home that is protected like the home itself, and we cannot enter curtilage with the sole intent, basically, to go there and recover stolen property. That is Collins v. Virginia, U.S. Supreme Court, where officers enter curtilage to recover a stolen motorcycle. So if this is curtilage, which it may be because of the fence and everything, then no, you cannot do it. You will lose that. You will lose the Fourth Amendment case on that. In other words, that trailer will likely be suppressed as a fruit of the poisonous tree because the entry would be unlawful. Okay, but Anthony, it's actually not curtilage. It's just almost like a business lot, and it's a company lot. It's closed. It's not. There's no homes on it, and so forth. Okay, well, I got the good news and the bad news. The good news is that I don't think constitutionally the evidence would be suppressed if you actually broke the lock and recovered it, because it's not a Fourth Amendment violation at this point. That area is not a structure, so it's not like you're going in. I don't think the courts are going to look at it as that highly protected. It's probably an open field, and just because there's a fence around it does not necessarily mean that what's within it is not an open field. That case is Dunn, Dunn, where the Supreme Court said that in that case, the cops hopped like four fences and saw evidence in plain view. They didn't recover anything, but they were, according to the U.S. Supreme Court, they were lawfully present under the Constitution, and there was no Fourth Amendment violation by them looking at the evidence inside a barn and then leaving to go get a search warrant. That's kind of probably what's going on here. It's probably not protected by the Constitution. However, in the vast majority of states, breaking that lock and entering that fenced yard would absolutely be a crime. Okay. It would at least in most states be a criminal trespass, maybe even a burglary. But some courts may struggle with how can you be charged with burglary by stealing your own stuff back. But I've seen cases that, by the way, I've seen that. I've seen courts say that you have no right to go enter a structure, right? But some courts, some laws include gated lots. You don't have the lawful authority to re-enter a locked gated area to go recover your own property. That would be burglary under the law. So you have to look at your state law and so forth. But the point is, no matter what, in every state, it's going to be a crime to some degree. Why would officers commit a crime to recover evidence for the victim? We don't commit crimes. We catch criminals. We don't become criminals. So this is not going to work. Okay. If I'm on scene with this case, I am absolutely not letting my cops cut this guy's lock in order to recover the evidence. A, I want a good case, and B, I don't let my cops commit crimes while we enforce the law. The last thing is maybe you have exigency. There's nothing here to say we have agency, but maybe you can give me some facts where, Anthony, if we don't get this trailer right now, we're going to lose it because we can't. I don't know. I mean, I'm going to make whatever I say after that would be making up facts, which I don't want to make up. Give me some facts that you maybe have agency, but the point is you probably don't. So at the end of the day, tell the victim, hey, we're gonna get a warrant. It's gonna take a while. Have a seat, and we'll get your property the right way. I hope this discussion helped you. I like talking about these things. If you have any questions for us, leave them in the comments below. Share this video with your friends. Please hit like. That actually tells YouTube that this video is worth people's time. People in your position. A lot of people that watch the same your videos are probably cop videos and so forth, and it'll show to other cops. All right. Until next time, my friends. You stay safe.